essentially Kik saying, give me money so that I can keep begging the SEC to sue us.
Hi everybody, this is fully-collateralized with Masha and Xenia. And for the past couple of months, we've seen a bunch of sensitive topics coming up in the crypto and blockchain space. Probably also a sign that crypto winter is over. But there have been a lot of discussions all over the internet and more traditional media, like Tether not being collateralized by cash. Craig Wright's copyright claims to Bitcoin's code and branding. So there have been a lot of discussions around this.
Yeah, and actually we realized that there's no universal or just right opinion on each of the sensitive topics. But one thing you really can't ignore is the legal aspect of all these
legal
questions.
implications.
And that's why today we're talking to Marc Boiron and Rebecca Rettig from FisherBroyles. We hope that they can shed some light on the essence of these topics and make it a little bit clearer for us and for you, our viewers.
Yeah, from the legal standpoint. Hi, Marc. Hi, Rebecca. It's a pleasure to have you with us today on Value Tokenized. Thank you so much for joining. Can you tell us a bit more about yourselves and the business you're in, the projects you're focused on at the moment?
Rebecca,
my name's Rebecca Rettig. I'm a partner at FisherBroyles. I'm primarily in the litigation department, but I'm also in the blockchain and fintech practice group. I've been focusing on litigation in the blockchain space for probably about 2 years, both on the regulatory front and in private litigation. So I've been doing some regulatory due diligence on companies and helping certain more traditional Wall Street companies understand the regulatory space around crypto and blockchain, and then also litigating cases, whether it be between traders and exchanges or founders disputes, internal investigations in companies. So I sort of do it all. And yeah, that's where I am right now.
And I'm Marc Boiron, also a partner at FisherBroyles in the fintech and blockchain group. I've been in the space for the last 2.5 years or so, representing companies kind of across the gamut. So I work on just kind of more traditional token sales, security token offerings, work on companies mining operations, work on some crypto funds. But essentially just represent companies in the blockchain space, advising them on regulatory issues.
So I think today we have a lot of topics to discuss because there have been a lot of information, a lot of news recently that involve different regulatory bodies of the United States expressing different opinions. And so I'll probably start with a question regarding FinCEN. So just recently FinCEN published new guidelines on how anti-money laundering laws apply to crypto. And now it basically means that any issuer of tokens which are not securities are equal to money transmitters. And we saw a really funny joke somewhere, I think somewhere on Twitter, that if previously token issuers and their lawyers were doing their best to convince regulators that the tokens are not securities, now they will do their best to convince that they're actually securities and not money. Yeah, so what is the situation? How does it look from the legal perspective? What power does these guidelines have?
Yeah, so FinCEN released these guidelines, I think, pretty early May. And the interesting thing is the way they presented it was that it is really nothing new. It's that they're essentially summarizing what has already existed. But I think most people would say that it also clarified a lot of what they were saying, and in clarifying it, brought up some new issues and also gave insight into how they're looking at things. I think generally speaking, it was probably some of the more favorable guidance we've actually received from regulators, in that it was mostly what people expected, and that if you categorize things in the idea of like centralized versus decentralized, the general idea is, if you're centralized, you're going to have money transmitter obligations. That's not necessarily surprising. And if you're decentralized, then you're probably not going to. Now, that falls on, exchanges being decentralized. So, that's really good outcome for DEXs, for example. Anyone who is, not hosting a wallet, that is probably good for them as well. But then there's some areas where, is a little less clear. So let's take dApps, for example. They kind of gave their thought on dApps and essentially said, if somebody who is going to use your dApp, which, if it's truly a dApp, it's going to be decentralized, but they're going to use it for money transmission purposes, then essentially the creator and operator of that dApp is going to be a money transmitter. Maybe not as black and white as that, but that was kind of the concept behind the guidance, which is a problem. And then I think the other thing that you kind of implied had to do with ICOs themselves and how those are viewed. And that's probably the most unfortunate part of the entire guidance. And it's actually not necessarily unfortunate because of the outcome. It's more unfortunate because it was so unclear. So if you look at the guidance and you look at how they analyzed exchanges, how they applied things to foreign companies, everything was really well reasoned and thought out. But when it came to ICOs, it was really more of like a couple blurbs essentially saying, if you're selling, a SAFT, which is a security, then you're probably okay. But if you're actually selling a convertible virtual currency, then you're probably going to be viewed as a money transmitter. And that all comes down to one kind of key concept that FinCEN, kind of a conclusion that they reached, which is to be a money transmitter, you're essentially going to, one of the ways to do it is to be an administrator. An administrator is one who puts a virtual currency into circulation and then has the authority, not the obligation, but the authority to redeem it, i.e. take it out of circulation. And essentially what FinCEN concluded is that if you're doing an ICO, then you are putting a virtual currency into circulation, which is accurate. And then it also concluded that you have the authority to redeem it. Now, whether that's, even though they make that as a blanket statement, whether that's actually true across the board isn't entirely clear. And so that's kind of the one aspect of the guidance that I could see, being challenged. But other than that, generally speaking, like I said, it was favorable. The one other part that was a little bit rough had to do with privacy, but it was, again, not unexpected, which is if you want to be involved in a privacy coin, and involved, I mean, as some kind of intermediary or transacting in them, then FinCEN's all for privacy coins, and I'm using that lightly, but they're not for actually remaining private while transacting in privacy coins with an intermediary. So if you're an intermediary, the FinCEN's view is you voluntarily chose to deal in a privacy coin. And so at that time, you are now obligated to register as a money services business because you chose to do that. And now you have all the obligations that come with it, which essentially means that private transaction can no longer be private.
I'm going to jump in as a litigator and Marc's lawyer and my own lawyer now, just to say that anything that we say on here is not legal advice. We're not your lawyers or the lawyers of anyone who are listening. These represent only our opinions of what's going on in the space. They don't represent the opinions of our firm and things like that. So I just wanted to put in those standard disclaimers before we keep going.
And talking about one more dispute that's what's all over internet and all over blockchain communities in the internet, and not only the Tether case, who just recently confirmed that it's not fully backed by currency reserves, and then that certain amount of funds was used to transfer to Bitfinex, and for you as lawyers, how does it look from both legal and ethical standpoints that USDT is not fully collateralized with the fiat currency?
Yeah, I mean, my view, it all comes down to disclosure and what everyone expects. And the problem is that there was an expectation that there was 100% backing by cash of USDT. And what we later find out is that it's closer to 70-something%, and then there is a note essentially backing the rest of it. and a note is not cash. So while you have to look at the credit worthiness to know, the likelihood that that's actually going to be repaid, when you think about it just from a legal perspective, my view is what was USDT disclosing at the time? And most importantly, what was it disclosing at the time that it was issuing, new Tether every time and redeeming it? And I think there was probably, my view is there was likely an issue with disclosures, given that we didn't actually, we thought, most people thought that it was 100% backed by cash, even though at times their website kind of hinted otherwise. It really wasn't ever clear, and everybody knew what was expected, and it wasn't the case, and so. I think that's a problem.
If you read the briefs filed by Bitfinex and Tether's lawyers in the case, they say that they did disclose it. It's one of the first things they say up front when they were looking to make their first appearance in the case. But I'll back up and just explain, although, as you said, it's been everywhere, all over Twitter and the internet and probably in mainstream news too, although I see that less today. But the New York Attorney General filed an injunction against Bitfinex and Tether after having worked with them and their counsel for months to get documents, to talk about the state of their business, to figure out what they were doing in New York, whether they were touching any New York consumers, and also to look at some of their dealings with each other. So they brought this case under what's called the Martin Act, which is an anti-fraud statute in New York. Lots of states have what are called blue sky laws, which are securities laws that are anti-fraud with respect to representations to consumers and otherwise. The Martin Act is known as having the most teeth of any of the blue sky laws and giving the New York Attorney General sort of the broadest reach. And so even after working for months, they brought this injunction because they basically said Bitfinex and Tether stopped complying with our requests as part of our investigation and part of us working together. So they looked to have the backing of the loan frozen for a period of time, the line of credit frozen, and they also looked to get more documents from Bitfinex and Tether. There were a number of interim steps, but where we are today is Bitfinex and Tether had filed a motion to dismiss and also a motion to what's called stay discovery. So on the motion to dismiss, what they said is, we don't have any contacts with New York. If we did, those were a long time ago, and they don't relate to the line of credit issue you're talking about. We don't have any New York investors right now. Whatever fraud you think there was has no bearing on New York consumers, and so you don't have jurisdiction, what's called jurisdiction over us. You can't reach us. And then they also said, and so for the time being, we shouldn't have to produce any documents. And the judge agreed because jurisdiction is one of these threshold issues, which is if you're not properly before the court can't, is not empowered to make you do anything. So all that Bitfinex and Tether have to do right now is produce documents relating to some jurisdictional issues. The New York Attorney General, after they get those documents relating to jurisdiction, will file their opposition to the motion to dismiss in July, so like 6 or 8 weeks from now. And then Bitfinex and Tether will file a reply, and then everyone shows up in court to argue before the judge, which will no doubt be a very interesting and very heated argument.
And my next question is related to a little bit different topic, the security token offerings. And it is well known that everybody, especially out the US, who is doing or planning to do security token offerings, they are afraid or hesitant to actually go and offer their securities in the US because they are afraid of SEC and their opinion. And like there is also like an opinion that SEC can't reach you if you don't go there. But this actually is not the case because it proved wrong when I think it was in this year when SEC actually fined Alex Tapscott and his Canada-based investment firm Nextblock Global for violating securities law and not complying with the SEC. Can you tell us why did that happen and what people who don't want to get into such situation, what they should be aware of?
So they should be aware of the issue that we were just talking about, which is jurisdiction. Are you touching U.S. consumers? Are you marketing in the U.S.? Are you having any contacts with the United States? And the other thing you should really think about, there are two other things. are you doing what's called availing yourself of the privilege of doing business in the United States? So are you using any modes of operating in the US to be able to further your company or your efforts to sell tokens? And the other thing is that you should be aware of, and there are a number of court cases that talk about this, is even if you say you're not taking US purchasers, do you have enough technical mechanisms in place to ensure you're actually not, and that you're doing true AML KYC to make sure you're not taking US investors? There's a case pending in the Eastern District of New York right now against a Canadian company, so it's an ongoing litigation, where the Canadian company made this jurisdictional argument that Bitfinex and Tether made, which are, we didn't take any US investors, we didn't touch the US, you have no jurisdiction over us throughout the case. The court decided to keep the case because US investors found a way to get through the AML KYC process and to be able to invest in PlexCorp. And so, you know, whether you touch the US is not just sort of a language, we're not taking US investors, but if you're really complying with what you say.
Yeah, and this comes down to really structuring things right, like upfront, and thinking about it. So you always need to distinguish between, you know, a US issuer with US people, and then a non-US issuer, and an issuer, I'm talking about the company themselves, along with you know, founders and other team members who are outside of the US. Because those who are outside of the US, you know, they actually have, I think, a real opportunity, if an opportunity, you know, might or might not be the right word, but they have an opportunity to stay out of the US completely, and it's really in their control. I mean, if they do KYC properly, they can truly exclude US people. They don't need to set up operations in the US. And in doing that, they just get access to a whole lot smaller pool of capital than they would if they were in the US. But you know, one thing that Rebecca touched on is faking that you are not taking US people, as has often been the case, especially with ICOs. You know, it doesn't work at all. And your defense that I tried to do it is not good enough, because bottom line is you can do it if you can. I mean, you know, there's you know, we saw this at the state level. I think it was in Massachusetts. You had this caviar case where, and it just shows you how far the regulators go, where they actually had one of the, I don't know if it was in the enforcement division or who it was, but they had somebody from Massachusetts actually go through the investment process. They actually put in a fake passport and then an address that didn't actually match the address in the passport, and they got accepted to then invest in that ICO. And so if you're doing, I mean, same thing at the federal level. If you're going to take that step, it's not going to help you. You know, as US people and US issuers, you know, it's a whole lot harder to actually, you know, truly stay out of the US. And you've seen companies kind of go to great lengths in terms of truth. They find their sisters and their uncles and their aunts to actually own the company offshore, hoping that they can be considered foreign issuers under Reg S, and you know, all these things like that. And ultimately, you really need to come back and look at, like, am I trying to build a business out of this or not? And frankly, if your only goal is to sell tokens, then maybe it actually makes sense. If your goal is, which you know, I would never endorse that, but if your goal is to actually build a business, none of that makes sense. I mean, to me, it's one of the funniest things when I get somebody who says, hey, I'm going to build this awesome business that my aunt's going to own. And I'm like, really? Do great. Actually, your aunt is. Like, it doesn't really make much sense. So I think that's something that needs to be thought about. And, you know, the whole IEO thing falls right into that, right? It's, you know, we've now got, you know, I don't know if this is something we're going to touch on, but, you know, you've now got ICOs that are essentially just, well, IEOs that are essentially just ICOs run through exchanges. And you've got all the same issues that you have with ICOs, except one thing that's interesting is people are actually being a little more vigilant now than they were in ICOs. I mean, look, Binance, I can still go onto their launchpad and invest in an IEO if I want, except I'm not being marketed that investment, whereas 2 years ago in an ICO, I was being marketed that investment. It's still a problem that I can go invest, but bottom line is it's completely different approach that most companies doing IEOs are taking compared to what they did with ICOs.
Yeah,
you also have, yeah, I think people are actually being more vigilant. The issue is what most companies are doing, and there's only been a few US issuers of IEOs. Most of them have been offshore. But most companies are doing that as a mistake is that they're taking things like Binance as a perfect example. And they're saying Binance doesn't take US people. And so we're going to go on Binance and they're not going to invest US investors. And they're essentially turning that blind eye, just like they did with ICOs, to the fact that, yes, there's probably very few, relatively speaking. But again, I can go and buy an IEO on Binance right now. But then there's other exchanges that truly don't actually allow US people. And not that I'm, endorsing going on those and how that'll work. I mean, it's going to be really difficult to keep those tokens outside of US people's hands, regardless, especially in the secondary market. And there's issues with them coming back into the US in the secondary market. But at least if you're going to a non-US exchange that truly does KYC, AML, and it truly excludes US people, that's going to look a whole lot better when you're in front of a regulator, or probably not a regulator. It's probably a private litigant who got their hands on those tokens and chooses to sue you. A US person tries to sue that company later. They're probably in a pretty good spot relative to the one who decided to go on Binance and ignore it.
It's really pretty funny regarding Binance. I found their post on their corporate blog dated 2017, where they said that they explored IO concept for a bit and then decided to stop and not dive further in it because it has a lot of questions,
like credibility
issues. And now, like, flash forward to 2 years.
Here we go.
Yeah, they seem to have overcome this issue.
Yeah, their view is they can turn it into something credible. But I mean, frankly, it's probably more credible than most ICOs in 2017. So maybe they're not wrong.
So all I was going to say is, and Mark alluded to this, but you have to think about the same from a litigation standpoint. And as Mark alluded to, having a private litigant come after you, you have to think of all the same types of issues that you thought of with ICOs and that we've been talking about. So will there be jurisdiction over you? Will there be a plaintiff who's damaged? Those kinds of things. And the other thing to really think about on the regulatory front is the SEC just announced that they signed an enhanced memorandum of understanding about cross-border enforcement. And the SEC and the CFTC both signed it. They've been part of a separate memorandum of understanding about cross-border enforcement that they signed in 2002, but they just sort of re-upped it. And one of the things they really pointed out, both in the press release and then in Jay Clayton's and Chairman Giancarlo's statements, was that there's new technology in the finance space. And that is really why they were sort of re-upping it and entering into the memorandum of understanding. You guys talked about the TAPSCOT action earlier. There was both an action in Ontario, an enforcement action by the Ontario Securities Commission, and then also an enforcement order here in the US. The Ontario Securities Commission issued theirs on April 1, and the SEC issued theirs 6 weeks later in May, and recognized the fact that TAPSCOT had entered into this settlement with the Ontario Securities Commission at the time. So there is cross-border work going on, whether it's very obvious or not, and certainly the memorandum of understanding reinforced that, and that's something definitely to think about when you're dealing with IEOs.
And talk about IOs, ICOs, and STOs. There seem to be multiple options for now to fundraise. But what types of tokens exist and how they differ legally? And what is the best way to choose one over another for projects? Like, in what case projects should look into each of these?
One of the things that I always say about dealing with any kind of digital asset is that it can represent essentially anything. And to broadly kind of categorize tokens is one of the hardest things to do, because the second you try to do it, somebody's going to be able to create or point out the possibility of creating a token that's different. But the way I generally kind of look at it is I differentiate what I'll call like protocol coins kind of differently from anything else. So that if you're creating a protocol and you truly actually need a coin, then that's probably the place where you have the greatest likelihood of actually being able to create a coin that is not a security. Whether that is in the, initially, whether, it's through some kind of fair launch, maybe some kind of airdrop, like a true airdrop, no kind of whitelisting, something of that nature, maybe you actually have the opportunity to create a token that's not a coin that's not actually a security. If you go ahead and sell it, even though it's for use in a protocol, and we see this with Blockstack that we could touch on, it starts looking a whole lot more like a security, and you start kind of needing to move in that direction. But I think that's like the first category of, hey, maybe we actually have something here that's not going to be considered a security. Once you move away from kind of anything in a protocol, then we kind of get to what we consider utility tokens, which I've always said a utility token can very well be a utility token. It's just most of the time going to be a security as well. The reason is because most utility tokens are used in a dApp, and the dApps start centralized, and most of them frankly are going to remain centralized. And so while that is a utility token and it might be useful in the network, it's probably still going to be a security. In which case, either you're going to sell it in violation of securities laws, or you need to start selling it just like you would with an STO. The problem there is that things start getting trickier because, when you're talking about a utility token, you usually want to use it in the network. When you want to use it in the network, you need it to actually be freely transferable, just like you would need in a protocol. And that's where you see, Blockstack, even though that's, a protocol, it would be the same situation if you're dealing with a dApp, where you're going to need the token to be used in a network. You're probably going to be having to look at like a Reg A Plus offering where you get free transferability immediately after the sale. And then when you move kind of a little bit further away from that, you get to what I'll throw in the category of true security token offerings, where you're dealing with something that has no utility, although you could add utility features to security tokens, which I think is a really interesting thing to do to add value in certain people's hands. Now you're talking about selling, an equity interest or a debt or, an asset-backed security, something of that nature. In those situations, the question really comes down to like, what are you trying to achieve in doing that? If you're an early stage company, selling, tokenized equity probably doesn't make sense, because the whole point of it in most instances, and there's tons of benefits, but most of them are ancillary compared to the potential liquidity. And to think that you're going to get a liquidity in a $2 million float really doesn't make much sense. And so you probably shouldn't be selling that. But then you go, to the other end of the spectrum, you say, should Apple, when regulations kind of make sense to do it, should Apple have, securities that are trading on a blockchain? And the answer is, yeah, probably, because you're going to be able to cut out a ton of intermediaries. So it probably makes a lot of sense to do it. And you could kind of go through the spectrum in terms of analyzing the different types of security tokens. My view is that those that are off chain right now that you're bringing on chain are things that we're going to need a few years to really make interesting for investors, because it just adds risk to what currently exists, but doesn't really add much benefit in an underdeveloped ecosystem right now. But if you could create security tokens that are something completely new, such as a revenue token that gives you a right to revenue, and all of that revenue is actually generated on chain through a blockchain-based business, where let's say you only receive, you use stable coins in the network, for example, stable coins to purchase things, and whatever you're purchasing is a blockchain-based asset, and then you're being distributed revenue based on that, then suddenly you start looking like you have an asset that really hasn't existed in the past, from which suddenly you can pull tons of information from from whatever blockchain it's on that you couldn't pull from a normal security. It starts looking like something that's a little more valuable than what you'd traditionally have. So that's, my view of kind of the entire spectrum of tokens.
I have another question in this regard, slightly from different angle. For example, when it comes to Ethereum, is it actually a utility token and can be considered as such, while right now it's mostly used, obviously, for storing value? What's your thoughts on this?
Yeah. So there's a couple things. I mean, first we've got Hinman's speech, which was, Director Hinman from CorpFin, his view in terms of, and I say that very intentionally, his view in terms of whether Ether is a security or not, because what essentially he said is, let's leave aside the point about whether Ether was a security at the time it was sold. Now it might not be considered to be a security. And so, there's that first, let's call it just a data point, where you've got the director of CorpFin that thinks that Ether might not be a security right now. And then you look at the SEC's framework, and the one that it issued maybe a month ago or so, or put out. So where FinHub essentially says, here's how you analyze whether a digital asset is a security or not. And then here is how you reassess whether a digital asset that is a security is still a security or not. So it goes to that whole point about whether a digital asset that starts as a security needs to remain a security. And I say that all because when you look at Ether, whether it was originally a security or not, seems from the SEC's perspective not necessarily to matter, because you can reassess whether it is or not. So if you reassess it, one of the key points is that you still need to look at each prong of the Howey test to determine whether it's still considered an investment contract or not. And when you say that ETH is used as a store of value, or that it's used for trading, and everyone's only looking at profit off of it, you're really looking at one prong of that, which is the expectation of profit prong. The prong that you're not looking at when you say that is whether those expectations or profits are based on the efforts of others. And when you start looking at that, then the SEC starts throwing in concepts of decentralization is the word that Director Hinman used, sufficiently decentralized. The SEC didn't necessarily say that, but used the same concepts as many people think of with decentralization, as in, is it a large group of actors that aren't necessarily coordinated that are working together? Or is it not? Is it still, what they called active participants, a few people who are working together or individually, and they're the ones who are driving everything in the network? And so when you look at the Ethereum network, and frankly, whether it's actually meets this part of the test or not is really hard to do. I mean, if you take Bitcoin, you've got half the people who are going to tell you that, there's two people who run the whole thing. And then the other half of the people are going to tell you that Bitcoin's actually decentralized. I tend to kind of fall in the later camp, and same thing with Ethereum. And so, maybe it's more concentrated in terms of who actually is validating transaction and can actually impact the network than you'd like. But I think when you look at it from a securities law perspective, you're probably in a pretty good spot in that there really doesn't seem to be a small group that is really able to kind of drive direction of the network, or has all the information relating to disclosure that you would want to know if you're going to invest in the network. So, my view, you're probably pretty safe in treating, Ether as a non-security. But I'm sure other people have different perspectives on that.
I think this actually dovetails really nicely to what the sort of growing chorus in the United States is with respect to regulations from the SEC, which is we need clarity, right? So today, Kik announced $5 million? They announced a Defend Crypto Fund, where they want people to start donating to their legal expenses in fighting the SEC. They, as many people know, they had received what's called a Wells notice from the SEC, which basically says, we're investigating you. This, I think, had come after they had been in informal discussions with the SEC, had given documents, had given depositions, and then they provided a Wells response through their lawyers. Which is a typical way to respond to a Wells notice. What was somewhat atypical is that they made their Wells response public. And then shortly thereafter, also made known that they had spent $5 million to date on legal fees fighting the SEC, or educating the SEC, however you want to look at it, but working with the SEC to try to come to some conclusion. There is a statutory time period by which the SEC is supposed to issue their decision on whether they're going to actually pursue an enforcement action or not after an applicant files their Wells response. That came and went last week without anything formal, one way or the other. So we don't even know what the SEC is going to do with Kik right now. But they did announce today this Defend Crypto Fund to fight the SEC, because they said that they've been trying to find a way towards settlement. They said that in their Wells response too, but to date they haven't been able to find an acceptable settlement. And they said that if the SEC determines it's going to go forward with an enforcement action, they plan to fight it in court. What they also said publicly today via a podcast was that they want there to be a whole new regime for digital assets in the United States to be able to determine whether they are investment contracts and thus subject to the US securities laws. And the thing I'll say is, and as a litigator, I've been saying for a very long time, these unofficial statements from the SEC are giving you, nothing. I believe in the court system, and, what courts say is legal precedent, and that's what you can really rely on. Unofficial guidance or even SEC enforcement orders are not this binding law per se. It's the written laws and then the decisions from the courts. So I don't necessarily foresee the courts coming up with a whole new test other than the Howey test. But I do think, and I've been saying for a long time, that education in the court system and through litigation is a really important mechanism by which to get clarity. Because the SEC has made clear that they believe that the traditional securities laws apply in traditional ways, and the only way you're going to be able to move that is through court opinions, which are binding depending on which court they're in and which state they're in.
Yeah, and one of the interesting things about what you just said is that I don't think many people have noticed, just based on the wording of this kind of defend crypto kind of website, as well as what Kik said, is that the SEC hasn't even brought an enforcement action. I mean, it's essentially Kik saying, "Give me money so that I can keep begging the SEC to sue us, so that we can then fight them," which is something that you don't really hear every day.
And I actually really thought, to egg regulators on publicly, I'm just not sure what the response will be. Although I will say it's a very interesting tactic, because the SEC has to decide whether they want to move forward, and that they really have a very clear view of what the violations were. And it's apparently still up in the air whether they are just pursuing the offering as being in violations of the securities laws, or whether any transfers of the tokens today also violate the securities laws. So they'll need to put forward a very clear theory of what the violations were and really present them to a court. So in the Block Vest case, which is another SEC enforcement action pending in California, they brought a preliminary injunction and said these tokens are securities. And originally the judge said, no preliminary injunction, you didn't meet your standard, SEC, to show us that these are securities, I'm not going to issue the injunction. The SEC came back and said, wait, let me show you some more things, and then please reconsider. And the judge at that time did, and then issued the preliminary injunction. So what I will say is really important about the court system is that there's a high bar for everybody. And whereas if you're just having certainly if you're having informal discussions with the regulator, there's a disparity in power. Because you really can comply. Whereas in the courts, everybody is answering to the same person under the same set of rules. There's rules, whether they're official or unofficial, and enforcement actions and unofficial and enforcement discussions as well. But the court system is really the best place to enforce it, because it's an even playing field, although just saying that, you have to be well capitalized for it to be an even playing field.
And I think for today, we'll finish our very interesting discussion with one more sensitive topic. We have a lot of sensitive topics today, which is Craig Wright's copyright for Bitcoin.
His claims.
Well, his copyright claims, yes.
He filed for copyright protection, both for the code and for the Bitcoin white paper with the U.S. Copyright Office. Right?
Yes. For the code, I'm not sure which one is even more impressive, copyright claims to the code or to the branding, so to say. But how does it look also from legal perspective, and what implications does the registration of this copyright kind of lead?
Yeah, I mean, there's a couple parts to this. So ultimately, what his goal is not really clear. Whether you're kind of pumping price of BSV, or whether you are looking to actually prove that you're Satoshi, not really entirely clear. I mean, the actual filing itself, all it's doing is giving it kind of a statutory remedy under copyright laws that wouldn't exist otherwise. It doesn't actually mean that the Copyright Office and the Copyright Office actually came out to publicly say that, it doesn't actually mean that the Copyright Office is saying that Craig Wright is Satoshi. or that it believes that, it literally takes it at face value when kind of granting that. So ultimately, what it looks like most likely happened, assuming Craig Wright is not Satoshi, is that Craig Wright essentially lied to the Copyright Office in saying that he is Satoshi. Now, the implications of that is something that Rebecca would know about way more than me, but bottom line is it doesn't look good when you kind of go to that grade of lengths to prove something, and unless you can actually prove it.
Yeah, I mean, the other thing I'll say, just to stay on my litigation bet, is he does have pending litigation where, he's trying to prove that he's Satoshi. So to use this as part of his litigation may be one tactic. To Mark's point, it's certainly illegal to commit any sort of fraud or misrepresentation on any of the US intellectual property offices in the United States. But the other thing is people can challenge a registered copyright, a registered trademark. And while I don't think this is his point, I mean, in theory, it should bring out the real Satoshi to challenge it. But, given the origins, that's just not something that, I think will happen. And, something that Mark and I have been discussing about this is to file a copyright over open source code is somewhat interesting because, to have protection over it is questionable given that it's been out there for a long time without any protection for free use. And frequently when you're filing for copyright or any other type of intellectual property protection, you want to claim the rights and to be able to use them to your benefit in the US or abroad in terms of licensing or, keeping it narrow.
Yeah, all right. I think that's it for today. It was awesome. Thank you so much, guys. Thank you for joining us at Value
and sharing your
Tokenized.
knowledge.
Thanks for having us. It was fun.
Thank you.
We had fun. Thank you so much. Thank you. This was Value Tokenized. Thank you for watching.
Subscribe to our YouTube channel if you haven't yet. Follow us on Twitter for shorter versions of videos. And ask any questions you might have to our speakers in the comments below. We'll make sure that all of them are answered. See you soon.